Okay. Yeah. Good afternoon. This is the time set for our Rule 26D Discovery Conference. I've read the joint discovery dispute statement. We have a dispute as to whether the defendant is or should be entitled to take a Rule 30b-6 deposition of a custodian of records for Banner Desert Medical Center. Ms. Thompson?
Yes, Your Honor. We do believe that there's good cause in taking the deposition of the records custodian. We have concrete documented discrepancies compared to the record that they supply online for their billing. It's not just trying to go on a dig here with Banner's overall billing practices. It's specific to this one plaintiff and specifically, and for a personal injury claim, the bills are at the heart of the personal injury claim. So we're trying to see if those billing practices are standard, if for whatever reason things were inflated or misbilled perhaps. So again, it's just for this one plaintiff and trying to figure out the billing in comparison to what they supplied online. The collateral source rule is not implicated at this time. It's just a deposition to get information as to Banner's billing for this plaintiff.
Okay, well, presumably you're going to want to use whatever information you obtain at trial if this goes to trial. So there is going to be a collateral source rule issue at that point, isn't there?
I mean, potentially, I guess if we get to that point, I mean, we do just want to see if we can use this as a means maybe for negotiation purposes at this point.
Is there any dispute that plaintiff paid the bill as prepared and presented by Banner?
No, there's no dispute as to that.
Okay. Mr. Spamer?
Regarding this good cause, there is no good cause. And I just went through their initial disclosure statement, Your Honor, and there's no mention of this dispute in their disclosure, and there's no documents presented regarding rate sheets or billing. So we're really having a hard time understanding what they're going after here. There is a concern that inquiry into the hospital billing practices as to who was charged and how much may open the door to collateral source issues and unfairly prejudice Ms. Martin in the eyes of the jury. Now, Ms. Martin was on Medicare. This was billed to Medicare. Medicare paid the bills, and the jury should not hear any of that. But taking a deposition of the custodian of records as to their billing practices risks unfairly prejudicing the plaintiff, Ms. Martin.
Let me ask you this, Ms. Thompson. I think I saw a reference that the total medical bills were $26,000, but what do you contend is the discrepancy between that amount and what you think Banner should have billed according to the rate schedules online?
I mean, it looks like from what I pulled in specific billing codes that it would be a few $1,000s. I mean, especially if it was supposed to be billed for Medicare, like the knee X-ray from the online rate sheet, it should have been $112. They said for minimum just general billing should have been $58.65. Max would have been $409.57, and she was charged for that same billing code $533. And then there's another one for an abdomen and pelvis CT. It appears that Medicare, if I'm reading the Excel spreadsheet correctly, would have been $617.57. General minimum would have been $241.82. General max would be $2,375.25, and the charged amount was $5,272. So there are some pretty drastic discrepancies from what was actually billed and what appears to be the listed amounts online.
Okay. I don't find good cause to allow the deposition of Banner, so I'm going to deny the request in the joint statement. Okay, that will conclude the hearing. Thank you. Have a good weekend.
Thank you. You as well.
Thank you, Your Honor.